The piece that I'm going to talk about today is very much a work in progress. So I'd love to hear your thoughts and questions about it. I know the format for this is generally like I'm going to talk and then Q&A, but you know, I've been doing this long enough now that you can go ahead and ask me questions and you're not going to throw me off. So if you have a burning question while I'm doing the presentation, please feel free to ask it. So the piece is called, at least right now my working title is, Will I Be the Next Hashtag? And really the title was inspired by a conversation that took place sort of on Twitter about, or in the wake of the killing, I believe it was, of like before the Jordan Edwards story ever happened. And so the conversation was about like what will happen if I, as a person of color, am killed by the police. Am I going to end up a hashtag on Twitter, etc.? And so that's where the title comes from. I wanted to situate the piece within that conversation because I'm specifically sort of trying to get at how you can protect yourself from being internet famous, right? Sort of infamous on the internet, or how your family can protect you after you've died. So that's the question that I wanted to ask. And actually, Jordan Edwards' story is the reason that I thought to ask this question. So Jordan Edwards was killed in Balch Springs, Texas, almost exactly a year ago by a police officer by the name of Roy Oliver. The details of the story have sort of shifted from the original iteration, but now we understand that Jordan Edwards was at a party. Someone called the police. The suspicion that the police went to the party to investigate, if you will, was underage drinking. Jordan Edwards got into a car with his brothers and two friends of theirs, twins, also 15-year-old kids, and those 5 kids drove away. As they were driving away, Roy Oliver shot into the car and killed Jordan Edwards with his brothers in the car and these 2 other 15-year-old kids. So the original story that the Balch Springs, Texas Police Department told was the kids were reversing, and so the officers were in danger of being hit. Well, there was video footage to the contrary, and the very next day, the police department had to recant that story. By May 2nd, Roy Oliver was fired. By May 5th, he was charged with murder. That criminal proceeding is still playing out in the courts. But the interesting thing that happened after that is Jordan Edwards' family came out pretty staunchly saying, we don't want our son's name hashtagged. We don't want his photograph everywhere, basically asking for the Twitterverse, if you will, to lay off. And so this got me thinking, is there a way for families in situations like this to sort of ensure that their child won't end up the subject of that kind of infamy? And because I had most practiced in the area of intellectual property, the first tools that came to mind for me were the right of publicity and the right to privacy, which are, of course, related things. And so I'll talk about the way that they are related and distinct from each other. Okay, right around the same time, this painting that you see on the left here was in the Whitney Museum in New York. It is an artistic rendering of a picture that I think is pretty famous of Emmett Till in his open casket. May Till, who you see there on the right, made the sort of conscious decision that Emmett Till's body was going to be, that the casket was going to be open. And so there's this famous thing that you hear recounted all the time. She said, I want them to see what they've done to my boy. And so Emmett Till's disfigured corpse is part of the iconography, I guess, of the nation's civil rights movement. And so you'll see the picture discussed all the time. Okay, the painting is by a woman named Dana Schutz, and when it was hanging in the Whitney, there was a huge protest. Well, not a huge protest, but there was a protest over it. And in particular, this African-American artist, with a number of other people, came to the Whitney and sort of stood in front of the painting, obscuring the view of the painting. And his assertion was, look, this rendering is like making a spectacle of Black Death. And so the protest was really about this question of whether Dana Schutz, who's white, should have painted this in the first place, whether the Whitney should be displaying it. The curators said, well, it's really, this is a sort of it's an important piece of the conversation, particularly in this moment where the question of killing Black boys is again sort of part of our national conversation. Dana Schutz, though, the artist, said that the reason she painted it was because she could empathize with Mamie Till. She said, I'm a mother too, and have a lot of empathy. That's not racially based, right? I have a lot of empathy for Mamie Till, what she must have been going through. And so this made me, this sort of, the happening of this conflation of things had me thinking about, well, what if it were, instead of sort of stranger and artists arguing about this painting Schutz had done, what if it were Emmett Till's family? Do they have a way to say, no, you can't display this painting, right? And so again, I found myself considering the right of publicity and the right to privacy as potential tools to deploy in this context. Okay, so I want to say, sort of right off the bat, what I'm trying to do in the paper and what I'm not trying to do in the paper, right? What I'm going to try to do in the paper is consider the viability of these tools for the tasks that I've articulated, right? To protect folks like Jordan Edwards' family, like Emmett Till's family. What I'm not going to try to do in the paper is consider sort of a larger normative question of whether protection like that ought to exist, right? And the reason that I've opted not to do that is because I actually think that's its own paper. Because there's lots of there, right? There's lots of stuff that I could talk about if I wanted to engage the normative question. So, you know, I could ask utilitarian questions like, is it more or less beneficial for society to allow families to make decisions like this? I could ask, within the context, sort of a historical question, right? Within the context of the civil rights movement, how important really was that image of Emmett Till? And given its importance, do we really want to allow families in their moments of grief to hold those things back, right? There are lots of questions there. Those are not the questions I'm asking in this paper. Not because I don't think they're important, just because I think they're a different paper. Okay, so this is sort of the layout of the piece right now. In the first part of the discussion of the piece, I want to talk about the right to privacy, the right of publicity, and protections for deceased individuals. And so, of course, in both instances, the likenesses, the names that we're concerned with protecting, those people are dead. As a rule, the right to privacy doesn't protect dead people. And so the question that I'm posing in the paper is, are there factual circumstances where the right to privacy ought to be protective of certain deceased individuals? The right to privacy and the right of publicity are, of course, interconnected things, right? So really teasing them apart is very difficult. And here, a page of history is worth like a canon of explanation. So I'll just speak briefly about the sort of where the right to privacy came from, and I think that brief discussion will explain why these things are so sort of conflated. Okay, so in 1890, Warren and Brandeis published what is maybe like the most famous law review article. It is called The Right to Privacy. It's in the Harvard Law Review. And in it, they articulate, before the thing really exists, a normative basis for the right to privacy, right? And so they give a number of reasons why we should protect the right to privacy. And they talk about previous cases in which courts have protected privacy through other mechanisms, whether the contract mechanisms or tort claims for trespass, etc. But they make the argument that the right to privacy should be its own thing, right? And they make that argument primarily because in this moment, the press and photography are sort of taking off, right? So the argument is based on this, or is motivated by this technological advancement. So that happens in 1890. It's not until 1905 that we get a court of last instance recognizing the right to privacy. So that happened in a case called the Vestige, decided by the Georgia State Supreme Court. And I'm going to tell you guys a little bit about the Vestige, because when I do, you'll see that really the first time that a court of last instance recognized this right, it was in the context of facts that we would now understand as right to publicity facts. Okay? So the plaintiff in the case, a photograph of him was used in connection with an advertisement for insurance. So that's how the case arose, right? Today, we would recognize that primarily as a misappropriation, right? The misappropriation branch of the right to privacy. That thing would also very likely, or that set of facts would also very likely, in many jurisdictions, give rise to a claim for infringement of the right to publicity. So I make this point here to make clear that drawing the line between the right to privacy and the right to publicity is often quite difficult, right? When scholars try to draw that line, they mostly do it by reference to questions about remedies. What is it that you want, right? If you want money, maybe that's a right of publicity. If you want to stop the use, which I think is the kind of remedy that plaintiffs similarly situated to Jordan Edwards' family would want, then that's really a right to privacy. Right? So the problem with that here in this set of facts is that the right to privacy, again, has never been recognized as protective of deceased persons. The right to publicity has, right? Not everywhere, but there definitely are jurisdictions where even after you're dead, you have, or your family has, your estate has, a claim for infringement of your right to publicity. So I find myself then in a scenario in which a couple of things are going on. First, because these regimes are state law, there's a ton of inconsistency from place to place, right? So if we want to answer the Jordan Edwards question, maybe we answer that question by reference to Texas law, because that's where the harm occurred. If we want to answer this question about the Emmett Till painting, maybe we answer that question by reference to New York law. We are going to have vastly different answers depending on which of those jurisdictions we're in. Because in Texas, the right to publicity is protected post-mortem by statute. Right? But in New York, the right to publicity, there is no post-mortem aspect to the right to publicity. And the New York story is actually an interesting one because the New York statute passed originally in 1903 is the very first statutory pronouncement on the question of privacy. It's a privacy statute, though it reads very much like a misappropriation statute. So if we're talking Jordan Edwards in Texas, maybe the family has a right to publicity claim because there's post-mortem protection there. But if we're talking about Emmett Till and we're in New York, there is no right to publicity claim there because there's no post-mortem protection in New York. So we have this inconsistency just in the nature of the regimes being both state law regimes. So that is added on top of the fact that, again, the right to publicity may give me damages and not what I anticipate these families would really want, which is injunctive relief. Now, of course, there is a strain of right of publicity jurisprudence that treats the right of publicity as like a property right? And so where that's the case, you can get injunctive relief, even in the absence of an articulation that you have been somehow pecuniarily damaged, right? And so these are sort of all of the complexities, or some examples of complexities that arise when thinking about whether the right of privacy or the right of publicity can protect, particularly those situated similarly to Jordan Edwards. Okay, so that leaves me at addressing First Amendment concerns, which of course there are lots, right, of First Amendment concerns. Both the right to privacy and the right of publicity make room for the First Amendment, usually by way of the question of whether a thing is newsworthy, right? So that would place us in the position of asking whether the name of a victim or of someone killed by a police department is newsworthy, right? This is, of course, a question that is addressed in some contexts by reference to protections for victims of crime, right? So this is the piece of the paper that I'll tell you guys right now I don't know nearly enough about, right? So the things that come to mind here are like rape shield laws, which I just don't know enough about yet to be able to analogize from to this context. But so there are contexts, right? If you are, for example, a minor that is the suspected victim of a particular type of crime, I know in California you are protected, your name is protected from disclosure to the media by way of, I believe, a constitutional provision. So the protections for victims of crimes, we've been talking about inconsistency, or I've been talking about inconsistency of the right to privacy and the right to publicity, even more so in this context. And I'm definitely in the context of protecting victims of crimes. And I definitely don't have my hands around that piece of it yet. But that's the kind of thing that I would be thinking about in the protections for deceased persons. And I suspect it is where I will find some basis from which to argue that there are instances in which the newsworthiness must cede to the need for privacy, right? So that's the research that I am deep in the weeds of right now. Okay, so then these are the kinds of solutions that I've been thinking about. So theoretically, we could extend privacy rights to cover some deceased persons in some instances. Okay, hugely difficult, right? Because that means I need to address my concerns to legislative bodies in 50 different jurisdictions, right? And try to get them to all do the same thing, when they haven't all done the same thing about privacy for ever. So that seems unlikely. I could address my concerns similarly around the right of publicity. There's at least some more statutory stuff happening there, right? Which is to say that a number of states protect the right of publicity by way of statute. And so the legislature is definitely, this is sort of in their wheelhouse, if you will. But again, there's very little in the way of committee of statute or application for right of publicity across these various jurisdictions. So that also seems like an uphill battle. And then the last piece is whether this is a place where we can have sui generis protection, right? Protection specifically for folks, particularly minors, killed by police officers. That is a live question. I am very likely going to end up here making the assumption that this is your best bet, right? If you want to protect folks like Jordan Edwards and those similarly situated. I still think it is an uphill battle. But I think if there are inroads to make there here. Part of the reason I think that is because you may have noted that very often we know the names of victims of people killed by police before we know the names of the police officers doing the killing, right? And so I think there's some space there to make an argument that these things should at least be in parity. So that is sort of where I am on the piece at the moment. Like I said, it is very much a work in progress. And I'd love to hear your thoughts, questions, etc.
I have so many questions and comments. I'll have to restrain myself. I know I'm going to, so I'll whatever. So a couple of small things. Just jurors sometimes get to be anonymous, right?
Mm-hmm.
So that might be just something to look at. And you might be aware of this in New Hampshire. We have a lottery winner who won a giant windfall, I don't know how many millions of them, $500 million, and they want to be anonymous because they fear their life will change. They want to be able to, go to the grocery store without getting mobbed by people looking for money.
Right.
So far, that person's not having any, do we know it's a woman? I think we know it's a woman. So far, any success, because the countervailing public interest in making sure that lottery operates legitimately supposedly requires her name to be disclosed.
Okay.
So that's kind of an ongoing, regional thing. I don't know how much national coverage you got. But my bigger question is just the pushback I know you're getting already or going to get from the First Amendment people.
Mm-hmm.
And I like the way you're trying to approach this very carefully and surgically, but I wonder how that's going to go, because I was also thinking with some of the people who were killed extra legally, and like the school shootings where it's not a police stuff. I mean, I imagine those issues I think come up then. But the question I have is if you're using social media, it's like sometimes the families want to use social media, like maybe a friend of the family put up a GoFundMe to help funeral expenses, lawyers, like the expenses that the family's going to have. And I think it's hard to say that's an okay use of the name, and then it's just hard. I'm not saying it's impossible.
Yeah. So I would say that that's fine. That it's fine for the family to use the name as they see fit, right? And I guess my theoretical underpinning there is sort of two-pronged, right? The first is about personhood. So part of what we associate with parenting is protection. And I would imagine, I mean, this is, I can relate to Dana Schutz's empathy here because, of course, like Dana, I am also a mother. And, I can't imagine that desire to protect your children ends when they die. So, in that sense, I think there is a really good basis for distinguishing between uses by the family and uses unauthorized by the family, right? And, you know, we have some sort of privacy, constitutional privacy type jurisprudence that speaks specifically to that question, right? That speaks specifically to the question of parenting as sort of within the zone of protection from at least governmental intrusion, right? So there are some analogies I think that I could draw from those bodies of law, but this is why I think I have to get at the Violence Against Women's Act and its protection for rape victims. Those kinds of spaces, because I suspect that this First Amendment argument was made in those contexts as well, right? And so to the extent that there are winning counters to that argument, my guess is that's where I will find them. Does that make sense?
No, it makes a lot of sense. It's a complicated project.
Yeah.
So I had two bunch of questions. One was sort of practical concern, at least on the Twitter side of things, the social media side, is Section 230 of the CDA. I mean, people they'll post up there, and I mean, the family's going to enforce, assuming they have a right that they can enforce. Getting Twitter or any social media account to take it down isn't going to happen with 230 in existence. So might be something to think about there if you haven't already. And then the other was with the exceptions to for crime victims, like you said, rape shield, and children being victims of crime. Have you found in your research anything that distinguishes between victims who are dead and who survive? Because what I imagine could happen, I'm not familiar with this at all, but what I imagine could happen is that you would have scenarios where it avoids First Amendment problems because these people were still alive and they may suffer these harms, reputational harms, throughout the rest of their lives. But if they're dead,
Right.
those concerns perhaps seem less.
Yeah. I have not found, I haven't gotten to that branch yet, right? Deceased victims versus live victims. But what I have found so far is that to the extent that rape shield laws, for example, operate, the reasoning behind that is about precisely the thing that you're getting at, right? The reputational harms, the sort of dignity harms, if you will, that can flow from being the victim of a rape. And so, yeah, I definitely think that's something that I have to, one way or the other, even if that distinction hasn't been made between dead and living victims, I still think I'm going to have to reckon with that bit of it, you know. Although I would say that, you know, similar kinds of narratives arise around, particularly around parents of children killed by the police. So if you think about like the narrative around Tamir Rice's mother, who was sort of pilloried in the media and very much sort of the subject of, well, she should have raised her son better, that kind of articulation. Well, so I would say that's not all that distinct, right, from the kinds of harms. Now that harm is flowing to mom and not to Tamir himself, but I would say it's not all that different. So, but yeah, I definitely will have to reckon with that one way or the other because the reasoning doesn't flow exactly.
I'm not usually too constant question jerk, so I'm going to try not to be too constant question jerk. I'm really fascinated by your use of this term extra legally, and you know why you chose not to say something more direct, like protecting those murdered. And so the terminology question is interesting to me. I'm wondering if this idea that newsworthiness in these cases gets trumped by a privacy interest is going to be an uphill battle, given that we're talking about murdered children compared to like Hulk Hogan's sex life, right? If we said videotape of Hulk Hogan cheating on his wife is newsworthy, and everything feels newsworthy, and this at a minimum feels so much more newsworthy than what courts have put in that bucket. terms of framing, I think a lot of people, Bill McGovern is starting a book project, I think, and there's been a lot of thought recently about this intersection of rights of privacy and rights of publicity, but typically focused on celebrities, typically focused on the construction of self and the protection of things that are not quite IP. So you're looking at kind of a negative version of that, which is really interesting. And one thing that came to mind was some right of publicity cases that seem to lean a little bit on the fact that a celebrity or an artist did not exploit rights in a particular way. So when a Tom Waits or a Beastie Boys or somebody comes forward and says, you know, I object to this commercial use of my name, image, or likeness precisely because I've gone out of my way throughout my career not to commercially exploit this particular thing, right? So is there an analogy there that could be helpful in terms of, because we're not using this and we're working really hard to keep this name out of the news, we ask other people to do the same.
Yeah. So extra legally, as opposed to murder, yes, there's a reason that, and it's because the vast majority of these cases never even go to trial, right? And so when I say extra legally, I'm being a little bit snarky, right? In the sense that much of this happens outside of the purview of our legal justice system. So, you know, Tamir Rice's killer never even went to trial. That's what I'm getting at when I think it's more precise and also more pointed, right? Because murder is at the end of the day a legal conclusion. And we never even get there. This is all stuff that's happening sort of behind the back of our criminal justice system. So that's why I chose that terminology. I think you're right to point to the newsworthiness piece, that Hulk Hogan case. Yeah, I have so many problems with that Hulk Hogan case. Which, not the least of which is, I don't have a ton of sympathy for Hulk Hogan, to be clear. That's not my issue. My issue is if a right to privacy is the thing that can protect us all from that image, okay, yes, let's do that, right? Which I know is not a legal argument, but it's really how I feel about that case. But yes, you're right that in that case, if Hulk Hogan's sex life is newsworthy, then what isn't really, right? And I think the very next thing we said sort of gets at it, right? I mean, part of the reason Hulk Hogan's sex life is newsworthy is because he's put all his business in the street, if you will. And these folks really haven't, right? So in the same way that particular celebrities can say, well, no, I've gone out of my way not to engage in this kind of commercial exploitation, right? These families can absolutely say, we did nothing to inject ourselves into the public sphere, to inject our child into the public sphere in this way. Hulk Hogan can't say that. Whatever else he can say, he can't say that, right? And so maybe that's the distinguishing point. Did I get all your questions and comments? Okay.
So I love your project, and when I first saw the title and stuff, I thought a lot about the race stuff that goes on, and it's impossible to miss. I mean, when these cases break, the racial angle and the pushback and the assumptions that are made. Have you seen the Philando Castile tape when he gets killed?
Yeah.
To me, nothing made an impression. I mean, for some people, you could not make an impression on them until they saw that. Like, they just assumed he was wrong. He must have done something wrong. Please do not shoot him. He did something wrong. Then when you see what actually happened, there's like no substitute for that. And I hope that your project leaves room for that, because that's just such a powerful thing.
Yeah.
I don't know how his family felt about it. I know that his family raised a lot of money. They paid off all the lunch bills of the kids. They went to Minnesota. I mean, this is an amazing family. Apparently, he's an amazing guy. And you just don't get that if you don't see that. tape.
Right. No, I agree. And so that's why I said at the outset, I'm not going to answer the normative question, right? Because I do think it's such an important question. And if I were going to address it, if I were going to address that question, I would frame it from sort of a critical race theory perspective, right? And do the historical contextualization of images in the fight for racial justice, right? Because it's not just that Emmett Till image. It's like when we think about the civil rights movement, we can think of 100 different images, right? The children being sprayed by those water hoses and attacked by dogs. Like those images really were sort of central to shifting the narrative about civil rights in America. I totally get that. That said, I think that these things have to be able to exist alongside each other, right? We have to leave some room for families to decide whether they want their children to be central to that narrative, right? So Philando Castile's, the video of Philando Castile being killed is in the world because his fiance shot it and posted it to Facebook.
Well, the one I saw was actually the cop.
Okay.
So they released it as part of the.
Yeah, but there's
Yes,
that's how the imagery initially was sort of disseminated. And so, but it was her decision to do that.
Right.
And so I think that these things have to be able to live alongside each other. And for me, that is the best sort of framing for that discussion is critical race theory, because if nothing else, that body of scholarship aims at conceptualizing and figuring out how we get our legal system to understand the full humanity of Black people, right? And that question is a huge question, but autonomy has to be a piece of that, right? The kinds of decisions that Americans generally get to make about their lives, those kinds of decisions have to be left to people of color as well. So I think that these things have to be able to live alongside each other. So, you know, Tamir Rice's family has been very much out in the public, as has Jordan Davis's family. I mean, there are families that choose, that opt to be part of that conversation. They should be able to do that. But to the extent that you are not that family, you should be able to do that too. That's my gut feeling about it.
As I'm listening, I was drawn in particular when you started talking about the parity piece. I love the critical race theory piece of it, and I think that would be integral to the argument. But it also did strike me, and I hadn't really thought about it in that level, but we never hear the name of the police officer or the victim. And so that idea of a right to parity, and I think at that point in your talk, you were talking about right of dignity, you know, that's a hotbed of issues from a common law perspective. This idea of at least parity under the circumstances that kind of ties in the discussion of the right for someone to choose and to decide as a family. I think that's a powerful connection too. So that's the first point. And also I started to just think from a comparative piece, either here or in the future from the human rights perspective at a broader level, and what other things, other protections look like in other countries, probably in other instances. Islamic religion, you know, that comes to mind, and the dignity, the decedent, things of that nature. So some of the ways that might be addressed, or at least the reasons that those protections exist, might be interesting to at least analogize or to kind of set the stage as well.
Yeah, I haven't thought at all about the comparative approach. So that's fine. Because I'm sure there's some fruitful stuff there. Yeah, I think I am always struck by how far ahead we hear the names of victims, right? And sometimes it's, I mean, in this case it was days, but sometimes it's months before we know who the officer was. And that has always struck me as really problematic, because what happens in that space is the media sort of goes digging for like an explanation for why this particular person was killed by police. And so we hear sort of all the dirty laundry of the victim. And in the meantime, we don't even know who the police officer is, or whether the police officer has any of his or her dirty laundry, right? Part of what I've been thinking about in terms of the potential, the Murphy's Law, like the ways that this can go horribly bad, is that if we say that there's a privacy right here, right, then to what extent can that be utilized problematically, right? So to what extent can police departments then say, well, we can't tell you the name of the victim, so that there isn't sympathy there, right? So that we never find out that Jordan Edwards was an honor student and a football player and never got in any trouble, which is what happened in this case, right? We come to find out that Jordan Edwards, you can go digging forever and not going to find he's like your average 15-year-old kid, except if your average 15-year-old kid was on honor all the time, right? So, I definitely am thinking about how to, sort of the larger question of, if we say there's a privacy right here, does that then give police departments the opportunity to sort
Like a
of,
shield. Yeah.
right, to shield when that works to their benefit, and not to shield when it doesn't. So I haven't thought yet about how to stymie that, but that potential problem is definitely on my mind.
So students with questions? Or comments?
So, and on the comparative piece that Tanya mentioned, I was thinking about the right to be forgotten in Europe, and that itself isn't going to be too helpful to solve the problems. It's just a delinking request, at least at the moment, but it might be a place to look, at least for the underlying theory, why we're going to protect, these rights.
Right. Yeah, I hadn't thought about that
Might
at all.
be just a place to start. And then also on the, so you said you're sort of gravitating towards the sui generis protection. And you mentioned, I thought you said that we were thinking it would just be limited to kids in that scenario. The problem, of course, is bigger than kids.
Absolutely.
So is there a reason why you would limit it to kids? And
There is a reason.
Is it strategic?
Yes, it's the reason is because that's easier, right? It is, so I think that the crack could be kids, right? Which is to say, the first foray. I think this is the easiest thing to sell. I mean, that's what it goes to, a pragmatic reason. I think, arguing that we should protect Philando Castile, for example, is a little bit harder than arguing that Jordan Edwards' parents should be able to protect him, right? So it's really just a marketing ploy, is why I'm limiting it to kids in the first instance.
Which is ironic, given the
Yeah.
lack of marketing that you're trying.
Yes, but really, that's what it comes down to. I think that as a practical matter, getting this kind of protection for kids is going to be easier, in part because it's easier than to make the analogies to other instances in which we protect children who are the victims of crimes, and other vulnerable kinds of, you know what I mean? Those analogies are easier to make if the protection I'm arguing for is limited to children. Does that make sense? Yeah.
I'm thinking about your critical race theory.
Mm-hmm.
I know you're not. I'm still thinking about it though. I'm still thinking about it because what this is sort of coming down to is the person,
the deceased person being the property of whoever decides they want to make him, whoever decides they want him to be their property, essentially. So if people say, oh, we're gonna make him a hashtag because he's going to be the guy that finally makes the police accountable, or he's gonna, you know, and it's like,
Yeah.
there's so much that has to be gotten away from in order to even start the, why we should be able to do this, that paper could be an entire book, you know what I mean? It's just
Yeah.
like, oh my, I'm just sitting here like, you know, just
Yes,
thinking
that's why I
about
don't
that.
want to do it here.
No, I get it, I get it, but it's just, so I'm just here going, wow, you know,
There's a
so.
ton, and that would get me into like all kinds of NCAA.
Sure.
Oh, Lord,
Yeah, yeah, yeah.
Lord, yes. I just am not ready to go there.
No, but I
Um,
think people would go there
Yeah,
pretty quick.
I agree.
I think people would go there. And particularly because the police, your sort of nightmare scenario, the police saying, oh, we can't tell you. Suddenly, you know, it's like you've decided to help get this law that sort of keeps the police, so the police can kill children secretly. You know what I mean? You know,
Right,
like,
right.
like there's, and again, that rests on all of these things are just the property of those who want to manipulate people.
Mhm.
And it's just so very depressing to me. that-
Yeah.
I'm
Andrew
sorry.
told me I had to be, I had to give a feel-good talk.
I'm sorry. No, I'm thinking about how screwed up, you know, how screwed up the conversation can be when, you know, the conversation can go bad so quickly. with
So many
people who
ways,
want- yes,
right?
Yeah.
And I think, this is why I think critical race theory is the right
Yeah, no, I
framework,
absolutely,
right?
yeah.
Because to understand really the implications of the various ways that this can go very badly, you
Yes.
have to understand how race has operated, in
Forever,
terms of property,
yeah.
how race has operated in terms of our criminal justice system, and in terms of privacy, right? So there's some good, interesting work about privacy and Black mothers, for example, done by a scholar out of BU, whose name is escaping me now. Her last name is Bridges. So, Kiara Bridges, is it Kiara Bridges? Yeah. So, you're right, there's a ton of stuff there that I cannot do here, and there probably is a book's worth of discussion there, but I just am not yet situated to engage that project. Though I think it would be an interesting one.
Anybody else? Well, of course.
So I'm just thinking of Facebook and Twitter and all of the other social media platforms and their privacy policies and their terms of service and how that may or may not apply here. So if you have an injunction, or the family has injunctive right to protect their deceased family member, what's to stop some person to just create their own hashtag? And what is Twitter or Twitter's responsibility to then at least that take it down?
Right. So we have a good model for legislation that social media sites are used to seeing, and it's the DMCA, right? So the DMCA is sort of the, I think anyway, the gold standard. The DMCA has lots of problems, right? But in terms of getting social media sites to take stuff down, the DMCA actually works to do that, right? Maybe too well, but that's a conversation for another day. But so we don't have anything like that in the privacy context at all, right? I've written about that before, but it would have to be something like that, right? To the extent that there is sui generis protection, it would have to operate in much the same way that the DMCA operates to require ISPs to take stuff down. And then, there's still a problem there, which is an administrative problem, right? Because if I am a copyright content owner, I have minions, right? Who all they do is scrub the internet for my content, and that's how I police that. But if you are the family, a grieving family, how are you going to police that? Really? That gets really difficult. So I'll have to think about how to sort of stymie that in the first place, right? Because without running into the police killing children secretly problem. Yes, I get it. That's not easy.
I was just thinking about it when you asked the question more in terms of like restoring power, like just giving the family a little bit of power back after so much has been taken from them.
Yeah.
That works.
Yeah, but if I want to make that concrete in some way, I'll have to think about these like intricate complexities.
I'm sure Professor Keller would be willing to talk to you one-on-one if you wanted to ask your
Absolutely.
questions personally. So let's thank you.
Thank you.